All right, welcome to the video lecture for Chapter 4. Chapter 4 covers equal protection, and equal protection is rooted in the post-Civil War amendment. So starting off with the 13th Amendment, framers gave states authority, but that did result in some problems that the federal government could not continue. There were multiple issues. States bank and money versus national bank and money, federal aid versus state aids, and who was responsible for improving roadways and railways for trains, as well as slavery. So President Lincoln was elected in 1960. After that, we have multiple southern states secede from the Union, and Lincoln had promised to abolish slavery under the Constitution. In the territories, so we had this unique Missouri Compromise where territories had more control. The states that were under the Constitution had the right to have slavery. Territories maybe could not. Lincoln had said he would get rid of slavery in the territories. Dred Scott v. Stanford is a Supreme Court case from the 1860s where the Supreme Court ruled that even free black men could not be citizens of the United States. And then they, in quoting of the opinion, they had no rights which a white man was bound to respect. So if we think back to earlier content, the Supreme Court can overrule itself. If they choose not to, then a constitutional amendment has to be enacted, which is what we see these post-Civil War amendments to the Constitution. So in 1862, slavery was abolished in District of Columbia and then in all of the territories. In 1863, Abraham Lincoln issued the Emancipation Proclamation and set the national tone towards abolishing slavery. In 1865, the 13th Amendment was ratified, which formally abolished slavery. So the 13th Amendment abolishes slavery. We have many states pass black codes. They start to enact discriminatory laws that still resulted in black people, particularly in the South, being treated as if they were slaves. So in 1868, a couple of years later, we see Congress pass the 14th Amendment. The 14th Amendment provides black men and women citizenship and grants citizenship to all persons born or naturalized in the United States. The 14th Amendment also forbids state governments from denying their citizens due process of law or equal protection of the law. So the 14th Amendment is used to incorporate provisions of the Bill of Rights to the states. Excessive fines, cruel and unusual punishments, protections against search and seizure, fair trial, all of these things have been incorporated using the 14th Amendment as the vehicle. Section 1 of the 14th Amendment provides that all those born or naturalized in the United States are citizens of the United States and the state in which they reside. This is the Supreme Court case that overturns Dred versus. This is the constitutional amendment that overturns Dred versus Scott. The 14th Amendment continues to prohibit federal and state governments from abridging the privileges of citizens. Governments can also cannot deny citizens equal protection of the law or deprive them of life, liberty, or property without due process of law. So due process are the rules and procedures used to prevent arbitrary government actions and proceedings. So there's the procedures. Did you have an arraignment? Did you have a preliminary hearing? But there's also the substance. Are the laws themselves fair? Not just how they're enforced and policed, but is the content of the law fair, and does it help us achieve justice? So laws can be overturned on due process grounds for either reason. Further, the 14th Amendment enabled incorporation of the Bill of Rights to state and local governments. We do Our constitutional framework has been in selective incorporation, which means not everything was inherently incorporated. But at this point in time, the most recent incorporation occurred in 2019, which required states not to excessively fine their citizens. And most of the Bill of Rights has been incorporated. That contains civil liberties has been incorporated to states at this point. A couple notable exceptions are the Third Amendment, the Ninth Amendment, and the grand jury requirement of the Fifth Amendment. Now, Duncan versus Louisiana in 1968, the issue in this case was whether or not a jury trial could be denied for a sentence of 2 years of imprisonment. And the court said, yes, this is a violation of the right to a jury trial. This was the case incorporated, the Sixth Amendment. Lochner versus New York, did state laws forbidding a baker to work more than 10 hours a day or 60 hours a week violate the Fourth Amendment? The Supreme Court said, 14th Amendment, the Supreme Court said yes, because it does interfere. The right to a contract is a liberty, and the right to have a contract that has more hours, this interferes with the due process clause. Continuing on with this chain of cases, Griswold versus Connecticut, 1965. The Supreme Court found that a Connecticut law that made it illegal to have contraceptives if you were married violated the right to privacy within the 14th Amendment. And then we have the court in this case announced that there's kind of a penumbra and peripheral rights that are included with the 14th Amendment and the Bill of Rights, including your ability to have some privacy to make these types of decisions. So enumerated rights are those that are explicitly listed in the Bill of Rights. Enumerated rights almost all apply to the states, and they are evaluated under the strict scrutiny test. Unenumerated rights are those that are implied. Those unenumerated rights that involve civil rights, strict scrutiny is usually used. If they don't involve that, then the rational basis test is used to evaluate those standards. So we have Nebbia versus United States in 1934. This case was contrasted with the Lochner case that was just a couple slides back, where the court said that laws that are not arbitrary and have no reasonable relationship to public welfare, the courts are without authority to override it, meaning they can't change things. Now, 14th Amendment jurisprudence is very rooted in equality, which makes sense given the Equal Protection Clause that's contained within it. So some definitions before we kind of dive through. Prejudice is an attitude, usually a negative attitude regarding a person or thing. Discrimination is an action or behavior based on prejudice. So this is the thought, the attitude, this is the action or the behavior. So in democratic societies, we do have this freedom to think what we want, but when those thoughts are become socially unacceptable behavior, the government is justified in intervening. So thinking back a little bit, the 13th Amendment did not change the Dred Scott case. It did not change Plessy versus Ferguson, which said that separate but equal was okay. So it did not outlaw unequal treatment or even change the attitudes. It just kind of was limited to abolishing slavery. So the 14th Amendment becomes the tool to move towards greater equality. After these cases and amendments, we see Jim Crow laws become enacted, which very strictly segregates black from whites in all aspects, pretty much all aspects of life. So as we move forward to equality, we also saw laws that were passed that throughout the Civil Rights Act, throughout the push for equality led by John Lewis and Martin Luther King and Thurgood Marshall, who later ended up on the United States Supreme Court. Thurgood Marshall is the person who spearheaded the legal challenges to Jim Crow and argued Brown versus Board of Education in front of the United States Supreme Court. After all of that comes, Brown versus Board of Education comes in the 1950s, and we see other areas desegregated area by area. We then begin to see laws passed that start to prohibit discrimination on race, color, religion, sex, or national origin in employment, in education, in public and private sectors, including laws that are still very important today, like the Civil Rights Act. We also saw at this shortly thereafter, the Nixon administration formed affirmative action programs with the goal of spreading equal opportunity throughout America. They were designed to remedy past discrimination and prevent future discrimination, using race, sex, color, and age as deciding criteria. That those should not be your deciding criteria. Now, this is another thing to distinguish moving forward are disparities versus discrimination. So disparities are differences. They don't necessarily involve discrimination. So these are just being treated differently, notable differences. Discrimination is the differential treatment of a group without reference to their behavioral qualifications. It's a specific distinction. The criminal justice system is characterized and known for contextual discrimination, meaning that racial minorities are treated more harshly at some points and places in the criminal justice system, but fairly similar in other places. Now, an example of this might be the much higher arrest rate experienced by people of color, in particular men of color, compared to those who are white. There are other areas, though, where people are treated fairly similarly in the process. And then an important case using the 14th Amendment is Batson versus Kentucky. So the issue here, Batson had all of the black jurors removed from his jury pool. And actually, just really quick before we move back, affirmative action programs are still legal. They have been really litigated out, including fairly recently in Fisher versus University of Texas. There are still some that are going on against the University of North Carolina and Harvard, but affirmative action programs are still constitutional as of now. This might be something that we do see change, though. So Batson versus Kentucky. Batson, the prosecutor used their peremptory challenges to remove all jurors of color, all black jurors from the jury pool. And the Supreme Court found that use of peremptory challenges was unconstitutional. So peremptory challenges can remove any juror except for racially discriminatory reasons. We do have other cases that clarify that this applies also to Latino and Hispanic jurors as well as women. Now, rights versus privileges, this concept holds more import within the correctional system. A right is a legally protected claim and a privilege is one that's not. So inmates can sue wardens for depriving them of their constitutional rights. They can't sue for being deprived of a privilege. Within corrections, segregating racial groups, assuming they will be in conflict, violates the 14th Amendment. Correctional facilities are also required to accommodate those who have a disability, otherwise it is discriminatory. So throughout this chapter is really the point where constitutional law in race and racial disparity, as well as gender and gender disparity, which this chapter does not effectively cover, and sexual orientation, which this chapter also does not effectively cover, come into play. And so I think it's very important to understand that for these fundamental rights, you have the fundamental right not to be treated differently by government institutions based on your race. And if you are, then the strict scrutiny test applies. When something violates strict scrutiny, it is almost always struck down. If it does not violate these important rights, the right to vote, the right to marriage, the right to these essential things, then the courts are much likely to apply a rational basis test. And as we saw at that Nebbia case, the government will usually win under a rational basis analysis. Sex-based discrimination based on gender, biological sex, is treated under intermediate scrutiny. Also, we'll note the 14th Amendment was the primary driver of the Obergefell v. Hodges case, which allowed marriage which made marriage accessible to those who are LGBTQ. And we did have a recent case as well, Bostock versus Georgia, which says that people cannot be discriminated against in the workforce based on their LGBTQ status very recently. So there's a lot here. This is one of the chapters in the book that I think is the least effective at conveying the importance of the issue as well as the standards. So if this is something that you find very interesting, please let me know. I have more resources that I'd be happy to provide and share and direct you to. If you have any questions about the material, please let me know. I look forward to working with you.